If you are just joining us, please, as a reminder, please mute your microphone. And if you have questions, please go ahead and enter them into the chat bubble, and we will address those questions as we proceed, and we'll definitely leave time for questions at the end. So I'm Suzanne Kirk, Leadership Southeast Georgia Facilitator. I hope that you and your families are healthy and safe during these very unprecedented times. This is the first of several Leadership Southeast Georgia virtual sessions that we will be conducting. And for many of us, this whole world of video conferencing is relatively new, and we are optimistic that today's session will go off without any major glitches. And we ask for your patience if we do have any glitches. We want to thank our program administrator, Cynthia Craddock, and her colleagues at Cecilia Russo Marketing for setting up this GoToMeeting. And we're very thankful to have all of you joining us live, as well as our speakers, Sarah Lamar and Wade Herring with Hunter McLean, which we will introduce shortly. A technical tip, again, please make sure your microphone is muted. Use the chat feature for questions. I find it helpful for connectivity when I close out every other browser and application when I'm participating in a web conference, and perhaps that will help your connectivity as well. This session will be recorded and made available to all of our Leadership Southeast Georgia 2020 class members, as well as our alumni and those that choose to participate virtually via the recorded session. Today is our live session, April 2nd, 2020, on what would have been our third in-person session of the Leadership Southeast Georgia program. We are working very hard to ensure that you class members of this year's class have as full and rich an experience as possible. And we are working to bring you these virtual sessions on a fairly regular basis until we can hopefully meet again in person. Our board and all of our program partners continue to monitor and follow all orders of this daily changing landscape. As of right this second, we are optimistic that we will see each other again in June for our live session in Chatham County. That is still planned to be a 3-day session in Chatham in June, and then we will do our follow-up and final session in August in Liberty County, which will also be a 3-day session. That means that your homework projects will also be moved to the August session as well. Again, all of this, as we know, is pending to change every single day. So before we introduce today's objective and our speakers, Wade Herring and Sarah Lamar with Hunter McLean, you know we always start our programs with a brief review, preview, and big view of where we've been and where we're headed in context of our larger program objectives. It seems like a really long time ago, and certainly an entirely different world from when we were together last month in Bullitt County for our education and agriculture session. I know we are all, probably those especially with school-age children, even more thankful now for all of our educators in our region. Part of our discussion last month when we talked about education focused on workforce development. We discussed best practices as it comes to performance management strategies. We discussed strategic considerations for your HR function. We talked about just various best practices in HR initiatives for your workforce at every stage of the employee life cycle. We talked about some of the compliance requirements for your HR function. And overall, we had a theme of what is the culture that we are looking to create within our organizations. And I think as we fast forward to today in this vastly different world, those things are perhaps even more important about how you are connecting with your teams, how you are communicating. At the beginning of this process, you know, I joke with some of my fellow HR geeks that embrace the Myers-Briggs studies, and you know, the introverts are maybe kind of loving some of this self-quarantine work from home, and the extroverts are in some cases bouncing off the walls. Although I did speak with an introvert colleague yesterday that said, no, it's worse because everybody's expecting that every meeting is with a video-based component, and it's even harder than some of the phone calls. So, you know, how are we considering our communications with our teams right now? How are we setting expectations about what work is realistic and critical to be accomplished as they work from home? And I know many of you in your organizations are facing very difficult decisions or have already had to make some very difficult decisions, and our speakers will help clarify some of the differences between a furlough and a layoff and reductions of hours and all of the different components that are coming into our world that perhaps we've not had to deal with before from an HR perspective. One of the things that I hope we can all do is to continue to find some of the good in these crazy scenarios. And I don't mean the people that are posting on Facebook that they're planting gardens and learning the cello and making soap from home. I mean, when we are on these web conferences, we see a glimpse into the human side of our colleagues and those with whom we work in various capacities. And I think that's a really valuable component that we can take away from this process is, you know, if your kids climb onto your lap while you're doing a video conference or the dog starts barking, we're all human. And embracing that component as much as possible and extending that to how we treat our employees, regardless of where we stand with the business operations, is paramount, I would argue, more than ever. So our objective today in this ever-changing landscape is to hear from some of our employment law experts about the workforce impacts of this pandemic and how some of the new requirements and benefits that are available to employees need to be navigated by employers. There's some information that we all need to know versus whether it be us personally as an employee versus as an employer making decisions. And they're going to break some of that down for you today, knowing that it literally is changing every day. And I know it's an overwhelming amount of information that we're all trying to keep up with. So some of the things they'll touch on are the FFCRA, the Families First Coronavirus Response Act, the changes to the partial unemployment process, and just some other high-level information that you need as you navigate some of these employer decisions. A little data for context. I'm sure everybody saw some headlines this morning that are just staggering, that 6.6 million unemployment applications came in last week alone. The week prior to that was 3.3 million across the country Department of Labor unemployment claims. As a little bit of context or a frame of reference, you go back to our recession in 2009, the highest week of unemployment claims then showed 594,000 claims. In 1982, in that recession, the highest week showed 665,000 claims. We're at 3.3 million last week alone. I was on a call this morning through the Georgia Chamber with Labor Commissioner Mark Butler, and he indicated that historically in the state of Georgia, Department of Labor applications were averaging about 2,000 a week, and last night they processed about 100,000. And so their systems folks are working incredibly long hours in order to operationalize some of these technical changes to how we process unemployment, and our speakers will address with you some of the processes for you to take and how to tackle just some of these common issues that we as employers are facing. So again, this is the first of several. We'll get you some more dates and times, but we hope to keep them basically at this schedule, the Thursday at 11 for the next couple of weeks as we schedule some sessions, and we'll get more info to you. So as we go forth, as a reminder, please make sure that for now your microphone is muted. And if you have questions, please go ahead and use the chat bubble to enter your questions. It's up at the top right of your screen. And we will read those questions and I will ask them on your behalf, either throughout the discussion or at the end. So at this point, I'm thrilled to introduce our speakers. We have Wade Herring, who is a partner in the Hunter McLean Savannah office, specializing in employment law, representing business and management, and his practice focuses on all aspects of employment problems and issues, including internal employment practices, wage and hour issues, drug testing, sexual harassment, equal employment opportunity, the ADA, and employee benefits. Wade is a frequent speaker on employment law topics, and I always enjoy the sense of humor and practicality that he brings to human resources managers and those in business. He is involved in many charitable and civic organizations, and he received his BA from Dartmouth and his JD of Law from University of Georgia, but most importantly, he's a Leadership Southeast Georgia graduate of the 2016 class. Then we have Sarah Lamar, who is also a partner in Hunter McLean's Savannah Office of Employment Law. She has experience representing employers in employment litigation in state and federal courts regarding discrimination in all aspects of various employment laws. She's also chair of the Government Affairs Committee for the Georgia chapter for the Society for Human Resources Management, which is the HR professional association, and she speaks around the state on legislative issues affecting the workplace. She has a BA in history from Yale, a JD from Emory University, and again, more importantly, is a Leadership Southeast Georgia class of 2018 graduate. Wade and Sarah, we're thrilled to have you with us today. For those of you that are following along, you can see Wade and Sarah. If you scroll across the top of your screen, you will see that they are socially distanced appropriately in the offices of Hunter McLean, it appears. And Wade and Sarah, it looks like your microphone is off, so if you want to turn that on, we are excited to hear from you, and I'll turn it over to you both.
Suzanne, can you hear us? Suzanne?
Yes, sorry, I was being compliant and I had already muted my own microphone.
Yeah, okay.
Yes, I can hear you.
Just want to make sure you can hear us. So thank you all very much, and I hope you see our appropriate workplace props that are in front of Wade and myself, the Clorox wipes, the Purell, and the gloves. So that sets the stage for our presentation this morning. Just a few words about the coronavirus that you are probably all aware of, but it helps just put a little bit of context into the importance of what we're going to talk about. Many people have stated that the coronavirus epidemic is the most serious public health threat since the 1918 flu pandemic. There are well over 100,000 cases in the United States alone.
Yes, ma'am.
And to put that in context, I think someone needs to mute themselves.
Yes.
Yeah. To put that in context, just last week, Wade and I gave a presentation, and at that point, there were only about 165,000 cases worldwide. So now there are 100,000 in the United States alone. The medical advice and expertise on this pandemic seems to be evolving. Most medical professionals provide kind of shocking concern about how long this may last. Some say, like the 1918 pandemic, it may be between 12 and 18 months, all told. The president has extended kind of a stay-at-home generalized order until April 30th. Some states have gone beyond that and expanded stay-at-home orders until June. The governor of Virginia has recently done that. Of course, Governor Kemp issued a stay-at-home order yesterday and closed all of the schools through the end of the school year. Within the last week, Mayor Johnson in Savannah issued his own emergency declaration, and folks have been subject to that in other municipalities across the state. So we also keep learning about how COVID-19 is spread, and that is a work in progress. I read, and maybe you did too, an article just yesterday about how now the advance in scientific research on this topic is revealing that it is probably not just spread through droplets from a cough or a sneeze, but also just aerosol. So exhaling can also pass the disease along. And we have folks who you might call super spreaders or entirely asymptomatic individuals who can spread without having any symptoms, or they might not experience any symptoms for 2 to 3 days and then experience symptoms, but they're contagious those 2 to 3 days when they're asymptomatic. So we're learning a lot at this point. Congress went into action to try to address this pandemic, first with some SBA loan disaster programs in early March, and then on the 18th of March, the Families First Coronavirus Response Act was enacted and signed by the president. So that the ink on that law is still wet, signed on March 18th. There are multiple aspects of the FFCRA, which is what I will call it, from assistance to needy children and health insurance assistance and those types of things. But for the employers out there, there are 3 main components to the FFCRA, and I'll talk about the first one, which is paid sick leave, and then Wade will talk about the expanded FMLA leave. For both of them, any covered employer, which I'll talk about in a minute, can receive tax credits for the payments made to employees for these covered reasons. So in that regard, in order to get your tax credits, it's going to be very important to keep documentation of why people are on leave. So that's kind of a big picture. In order to get the credit, you're going to need to show that someone was taking leave for a covered reason. So who is a covered employer? Covered employers are those with less than 500 employees. And many people have scratched their head about why Congress would arguably put this type of burden on small and mid-sized businesses, but not on the largest employers out there. And for that, I would say, talk to your congressman. But putting that aside, if you are less than 500 employees, then you are subject to these requirements. There is a possible exception for employers with less than 50 employees if giving leave would cause a great financial hardship on those organizations. You could be potentially excused by the Department of Labor from complying with that law. The Department of Labor has said, you know, don't come to us, we'll come to you. So what you have to do if you're deciding as a small business that we're not going to comply because of the undue hardship, and there's a fairly detailed analysis you have to go through for that, which just came out in regulations last night. But you just need to be prepared to defend that decision if and when employees go to the Department of Labor and say, I didn't get my paid leave, I should have received it. So going back to the sick leave portion of the new law, it says that for any one of 6 related reasons related to COVID-19, you can get your full regular pay for up to 2 weeks or 10 days or 80 hours. There is a maximum if you're taking leave for reasons that affect you directly. For instance, you have COVID-19 and are in self-quarantine, or you have a condition which a healthcare professional has indicated you must self-quarantine due to concerns regarding your condition and COVID-19, those would also qualify for paid leave. as would if you're actually diagnosed with it and you're in the hospital, for instance, with COVID-19. So for those types of absences that involve the employee themselves, you can be paid up to your regular pay up to $511 a day, or a maximum of $5,110 for the 10 days. So that's a lot of money. Few people are going to be entitled to $511 a day. For the other remaining 3 reasons under the sick leave provision of the FFCRA, those involve taking care of people who may have COVID or have to quarantine because of COVID-related reasons, or if the employee has to stay home to take care of children because of the schools are closed. The regulations that came out just added a tweak to that, that if you have a child who is over 18 but incapable of self-care, such as a disabled child, then you can also get paid leave to take care of that son or daughter. In those circumstances, the most pay you can get under the FFCRA is $200 a day, or up to $2,000 of sick leave. So that's the big picture under the sick leave provisions of the FFCRA. What are employees entitled to, and what must employers offer if these employees meet those conditions? I'll turn it over to Wade to talk about the expanded family medical leave aspect of the law.
Well, I want to back up just a moment, since this is a leadership class, and follow up on some of the comments that Suzanne made. I think leaders are optimistic, but I think leaders are also realistic. So I hope all of you are following the science on this. Sarah and I have been really wrestling with this since March 18th. And our business community is like people went to bed on St. Patrick's Day night realizing there had been no parade, and they woke up on the 18th and said, this is real. And so we've been dealing with this pretty much non-stop for what seems like a long time, but since for the last 2 weeks. And what I've come to realize is that the way people are processing this is a little bit like the stages of grief following the death of a loved one. There's denial, bargaining, anger, and finally perhaps some acceptance. I still have clients who think this is going to be over with by the end of April. It will not. But on the other hand, I think we will get through it. I've recently purchased The Great Influenza. I don't actually recommend you read it right now. It is available on Amazon. Leave the box out in the garage before you bring it in the house. But that influenza pandemic occurred 1918 to 1919. The lowest estimate of the worldwide death toll is 21 million in a world with a population less than 1/3 of today's population. And this is the part that really got my attention, and I'm just going to read it. And they died with extraordinary ferocity and speed. Although the influenza pandemic stretched over 2 years, perhaps 2/3 of the deaths occurred in a period of 24 weeks, and more than half of those deaths occurred in even less time, from mid-September to early December of 1918. Influenza killed more people in a year than the Black Death of the Middle Ages killed in a century. It killed more people in 24 weeks than AIDS has killed in 24 years. Those are staggering numbers. But the reason I bring that to your attention is because, yes, this is unprecedented for all of us who are alive today, but the world and our country went through a terrible pandemic 100 years ago. And then if you look at history, the 20s was a time of great economic opportunity and expansion, and a changing role for women. So we had 10 good years, After that, then there was the Great Depression and World War II, but that's another seminar. In terms of leadership, I do think you have to be realistic, you have to be optimistic, and you have to communicate to employees. Employees want to hear from the leadership of their companies, even if you think maybe it's something they've heard already or they should know already. They want to get nowadays that email from the company leadership. And I also think it's important for the company to be decisive, even though there's a lot of moving parts, including all these laws that Congress has passed. So as Sarah already talked about, under the Family First Act, there's this opportunity for paid leave that the employer can recoup with tax credits. But one of the questions for the employer to ask is, can I afford that because of cash flow and income? Sarah covered both the sick leave and the family leave part of that. The family leave is primarily for people whose children are at home. And as Sarah said, the way the act reads, it's for children under the age of 18. My clients seem to be on a spectrum from they've shut the doors to they have work to do and they really need their employees. And although the law says a child under 18, to me, there is a difference between a child of, say, the ages of 12 and 18 and a child under the age of 12. And if it's a two-parent home, there's also another adult there that can help supervise those children. So on the child care part of this, there is an opportunity for intermittent leave and for staggered schedules. And I think it's worth some hard conversations with employees if they're in the lucky position that they still have a job. Look, employee, I need you. I'll work with you, but you got to work with me because we need you to do your job. I want to go ahead and talk about what's going on with unemployment claims. You hear a lot of terms used pretty loosely: furlough, layoff. Furlough anticipates that you're going to bring that employee back. A layoff is used in the same way, although it's also used to mean a discharge. I think when you communicate with employees who are being laid off, it's important to communicate, we hope to bring you back, or right now we don't know if we're going to bring you back, so we will go ahead and discharge you. The difference, there are a number of differences primarily on benefits. If they're furloughed, if they're still your employee, that means they're still on your group benefit plans, and they need to pay their part of the premium, but you've got to keep that group benefit plan in place. There is some concern about the definition of eligible employee because it's tied to active employment. As a practical matter, if we're talking about 4 weeks, 6 weeks, I don't think any insurance company is going to challenge that. But as it prolongs, that's something you need to revisit. Are these people on these long furloughs actually still eligible for group health benefits? As far as the Department of Labor is concerned, if it's a furlough, a reduction in hours and therefore in compensation, or a discharge, the Georgia Department of Labor wants the employer to file the claim for unemployment, and you do that on a weekly basis. You go through a website. The instructions are actually pretty clear. Because of the heavy use, it's sometimes hard to get in, so it may take some time. But the employer is to file that claim for unemployment online. Again, whether it's a partial reduction, a furlough, meaning we hope they'll come back, or they're discharged. In terms of the benefits that the employee receives, that's paid for by the government. That doesn't hit the bottom line of the employer, and there's some confusion out there about that. And it's a formula. So under Georgia, prior to all of this, The benefits for unemployment range from $55 to $365 a week. And I saw some statistic that the average benefit in Georgia was $155 a week, and I'm not sure if that part's accurate. Under the law that Congress has passed, employees are going to get a flat $600 additional on top of whatever Georgia does. And some employers say, well, that means my low paid employees might make more on unemployment than they would working, and that's true. So that's going to be one of the challenges. And as I understand it, the benefit has been extended for right now, at least through the end of July. But again, in terms of that benefit payment, that's coming from the government, not coming from the employer. The challenge for the employer is, for those employees I need to keep on the job, how do I keep them on the job when there's this opportunity under unemployment? If you have employees quit, I would not file unemployment for them. If they're a voluntary quit, that's not your concern as far as I'm concerned in the middle of this crisis that we're in.
And Wade, I wanted to add a couple things to that. If you actually read the regulations to the Georgia Department of Labor unemployment comp system, which I wouldn't recommend, just like Wade's book, I wouldn't recommend reading that right now either. But it talks about only full-time employees are supposed to get partial unemployment, and that's not true during this crisis. So even if you see something that says part-timers don't get unemployment during COVID, that's not true. They are accepting partial claims, and again, employers must file them. You don't want your employees filing, and there could be some steep penalties for doing that.
Good question there, Sarah and Wade. If I can interject a question that I have received from a lot of employers regarding those unemployment benefits, that the language from the DOL indicates that the employee must anticipate returning for these partial claims, as I understand it. If the employer is filing, but they honestly don't know or don't anticipate that employee being able to return to work, are the employers still filing on behalf of the employees?
Yeah,
the feedback we've gotten, and you're right, Suzanne, that when you look at the website, the language suggests if it's a discharge, then that's treated differently. The feedback that we've gotten from DOL, both direct and indirect, is that if the discharge is because of COVID-19, and that's very expansive, DOL still wants the employer to apply. And they've made that pretty clear.
Yeah.
Great, thank you. And I also just wanted to remind class members, at any time as you have a question, please go ahead and use the chat bubble at the top of your screen and enter your questions so that we can make sure that your specific scenarios we can pose to Wade and Sarah for their guidance.
Just one follow-up on the Family First Coronavirus Response Act is that the pay for taking family leave up to 12 weeks, the first 2 weeks would be unpaid unless it's paid under the sick leave portion of the law. But the most you can get for those remaining 10 weeks is 2/3 of your pay, up to $200 a day. So there's lots of moving parts to that law. And another aspect of the Family First Act is that you cannot require employees to exhaust their PTO or sick or vacation before electing to take this leave under the Families First law. So a couple other thoughts under employment law that come into play with the whole COVID-19 crisis we're in is OSHA and something called the WARN Act, and then the Americans with Disabilities Act. So just a few notes on that. First of all, OSHA has a very good website. Just plug in OSHA and COVID-19 and you will find a fair number of resources from that agency about dealing with COVID-19 and for employers who have various workplace safety requirements, such as dealing with bloodborne pathogens or personal protective equipment. It can be very helpful in that regard, but also it tells you what you need to do to effectively clean a workplace and your cleaning crew and how to protect the cleaning crew who's going to clean a workplace if it's had someone at work who has been diagnosed with COVID-19. So there's some good intel there. With respect to the safety requirements, all employers under OSHA are required to provide a reasonably safe workplace for their employees. That's something called the General Duty Clause under OSHA, and that would be triggered by this crisis as well. But there are employees who have expressed, and Wade and I have both dealt with these, I'm sure Suzanne has as well, who have simply expressed a generalized fear about coming to work because of COVID-19. It's not that they're especially susceptible to COVID-19 or there has been someone they worked with in the workplace who tested positive by the disease. They're just anxious in general. And the anxious in general types, I don't think are entitled to leave under the FFCRA. I don't think they're entitled to unemployment benefits. But I also don't think they're entitled to not come to work under the OSHA standard. What the OSHA standard says is the employee must have a reasonable belief of being in imminent danger in the workplace. And I think as long as employers are following the guidelines of social distancing, et cetera, not many employees will be able to make out that argument. Do you see anything different there, Wade?
Yeah.
And then the other law that I wanted to talk about was the WARN Act. And the WARN Act says generally that if you have a plant closing or mass layoff, which generally involves folks either being laid off or terminated, at least 50 people at a single work site, and there's some other details there, but I won't get into those. You have to give at least 60 days notice to the employees, and during that period, they must also receive their pay and benefits. So in this type of crisis time, that is a great challenge for employers who are, laying off in large numbers, most, if not all, of their workforces, or furloughing or terminating, whatever phrase you want to use. They're sustaining a large number of employment losses. There is an exemption which many employment folks believe should apply right now, called the unforeseen business circumstances exception. And in those circumstances, you can give less notice and not be on the hook for all that back pay and benefits. We believe that the COVID-19 crisis should squarely fit into that exception for many, many businesses, although it is a case-by-case analysis. One thing that Wade and I have been sharing with our clients is, however, the longer you wait, if you decide in September, oh my goodness, we think we have to lay off everyone because of COVID-19, it may be a more difficult argument to make that the business circumstances were unforeseen if you did that. So you definitely want to speak to your employment law professionals, HR professionals about the impact of the WARN Act on what's going on. And Wade, the EEOC has gotten into the game in this too with some guidance.
Yes, the Americans with Disabilities Act is an issue here. People's medical condition and the confidentiality of that information. The EEOC has actually had an ADA pandemic website since 2009. That would have been a prior administration, but it's been updated most recently. So, for example, you can do things like take employees' temperature as they come in the door, and then that's a whole other set of issues. Who's going to take the temperature? They recognize that they recommend a radar gun type, but what protection will you provide for the person who drew the short straw that has to take everyone's temperature? If you've got employees who appear to be sick, send them home. If you have employees who are talking about someone who at home who is sick, you can ask some additional questions and perhaps send that person home. So the law is what you would hope it would be here, that the employer is allowed to be more intrusive, exercising common sense into the employee's health and condition to protect the entire workforce.
I think finally, before a question and answer period, Suzanne asked us to talk a little bit about the CARES Act, and Wade and I are going to give a full disclosure that we are not corporate and tax lawyers. So don't run from this webinar to the bank on anything we say. But the CARES Act is the third law that has been passed by Congress. That was passed, I think, Friday, signed into law, passed by the House on Friday, signed into law by President Trump the same day on March 27th. And that has lots of moving parts that are still being worked out through the IRS, interim guidance and regulations, and the Small Business Administration. But generally, the CARES Act is offering two types of loan programs. One is a paycheck or payroll loan program where employers are incentivized to keep their folks on payroll and pay them during this crisis. The other one is kind of an employer disaster relief loan program. The paycheck loan program is potentially entirely forgivable if you meet specific criteria. And the disaster loan is not forgivable, but it's a low interest rate and can last for a long payback period. They literally, as we speak, they're working out the nuts and bolts of that, and there is a lot of confusion about how it applies and how various different employers can take advantage of that. The employer thresholds, the business thresholds for those laws generally also follow the FFCRA, so it's employers with less than 500 employees, but there are exceptions to that, important industry exceptions, which before moving forward with any of those loans, the employer and the business would want to nail down. Anything more on that one?
Let me just add, there are loans available for businesses with more than 500 employees. And for all, as easy it is to criticize Washington, I've got to say the information has been coming out really fast. We already have regulations for the Family First Act. We already have frequently asked questions up on the website. There's already a loan application for the CARES loans. It's a 2-pager, so pretty easy. That came out yesterday or the day before, so really fast. There's $350 billion available under that CARES program. Everybody predicts that money is going to get used up. So if you're interested in that, you need to act quickly. It's also available for nonprofits. It's also available for churches, for private schools. Fairly remarkable piece of legislation. But again, the anticipation is that that money will get used up pretty quickly. Congress is already working on another round of legislation, but that's what's on the table right now.
And Wade just said something that triggered another comment under the FFCRA. Public employers, so state, local, public agencies are also covered by that. So that the requirement of having under 500 employees is not relevant to the public employers, which are generally covered.
Quick question on that we've gotten, and if I'm interpreting this question correctly, along the lines of the CARES Act, I think they're referring to stimulus checks. Is this recovery money going to be considered taxable income? Do you know? And I know that the tax world is not necessarily your area of expertise, but do you know if any of that is considered taxable income?
On the short answer on the loans is I don't know. I mean, I think they're a loan. Now, if they get forgiven, is that income? I don't know.
Yeah.
The unemployment benefits to the employees.
They can, under the Georgia GOL rules, for partial unemployment, the employer is supposed to ask the employee whether they want taxes taken out, and the employee gets to decide. I don't know whether later, I'm assuming later the employee has to make up for it if they say no, but what the Georgia GOL has said is it will take out 10% federal and 6% state if the employee does want taxes removed.
Okay, thank you. So then just a reminder, if people have questions, we still have a couple of minutes if you want to send in some of those questions, but I've got a couple other scenarios that have come up that I will ask to you. So I know some employers, perhaps in their handbooks, have policies regarding administrative leave. Is this an option right now for employers to put people on an administrative leave in light of all that's happening, or are all employers required to submit partial unemployment for their employees or find a scenario that fits the FFCRA?
I don't think it's on the employer to try to pigeonhole an employee into the FFCRA, but as Sarah alluded to, once upon a time the employer could require the employee to use whatever paid leave was available first, and now it's the employee's choice. The employee is allowed to make that decision. When you say administrative leave, I'm assuming you mean some kind of unpaid leave. Mm-hmm. And I think the employer, if they put people on unpaid leave, whether it's administrative in a handbook or a furlough or whatever they call it, if that employee is on leave and is not getting paid, the employer should apply for unemployment for that employee. And what the guidance we've been informed is, when this all first started, some employers were concerned about how this would affect their rating for purposes of unemployment taxes. What my understanding is, none of this is going to count. And quite frankly, in the scheme of things, that should be way, way down the list of what companies are worried about right now.
Absolutely. That was something that Labor Commissioner Butler discussed this morning. The Georgia Chamber is putting on weekly calls, as I understand it, and I just joined this morning because it was the Labor Commissioner, but he did clarify that these unemployment claims are not going against the employer's responsibility going forward. Another question about employees that were already on FMLA. So if an organization had an employee that was on a Family Medical Leave Act already, it's time for them to come back, but there's no work available for them to come back. How do the traditional rights of FMLA apply that guarantees your position be held for you? How does that come into play now when there's not work for you?
The law has been and remains that if the decision to furlough or discharge the employee is an economic reason, you're not targeting this person who is on FMLA, then the employer is allowed to make that economic decision. And that would also be true for people who are currently on leave, whether traditional FMLA or the or now the paid leave, if the employer, comes to a point within the 12 weeks and says, I can't do this, the employer is allowed to lay people off or close the doors. And obviously, if there's no business anymore, you don't have to keep paying people. Now, caution, you can't just, if you start your layoffs, you can't just start with the ones who are on some kind of protected leave. You can't target them. But if you're making broad economic-based reasons, then they can be included in those decisions.
And so you raised another question that has come up, that as organizations are faced with the tough decision of having to reduce their workforce, what is the process to go through to ensure it is a legally defensible, if it's not the whole workforce, and if you have people of like positions, how do you determine in a legally defensible fashion who has to go?
That's a great question, and I'm glad you brought it up. I have clients say to me, well, it was an economic layoff, therefore I can do whatever I want to. It's not quite that simple, because even when it's an economic layoff with multiple people, the people who get picked, if it's not everyone, the people who get picked still say, but why me? Was it because of my race or my color or my age or my national origin or my religion or my disability or because I was on leave? So what the employer has to do is come up with a set of criteria. Who do we need to help this business survive? What are their skill sets? What are their flexibility of skills? What is their work ethic? You might consider seniority. And then basically what you're going to do is you're going to rank people based upon those business criteria about who do you need to make it through to the other side. The documentation doesn't have to be particularly sophisticated, but you do need to be able to, at the time, explain and articulate your business reasons and the decisions that you made. For larger employers, ordinarily what we would advise is that you do a disparate impact analysis to make sure that you're not having a disparate impact on a protected minority. Quite frankly, things have been moving so quickly, even big companies don't have time for that right now.
Sure.
I would just add that for some employers are offering limited severance to their people who they've laid off, terminated during this crisis, and just trying to do the right thing by their people. And I understand that, and I understand the sentiment. However, if you're giving folks money on the back end, I would advise that you offer them the money in exchange for a release agreement, because otherwise you're just giving away free money. And to Wade's point, someone could say, well, yes, I was laid off. I understand it's the COVID-19 crisis, but why me? And therefore, I'm going to sue you for whatever type of discrimination because it shouldn't have been me. Well, if you're giving people severance and they can still make that argument, that's not a great position to be in. So I would have employers strongly consider, if you're going to give anyone any severance, offer a release along with it, that you only get the severance if you sign the release of claims.
And would the typical state requirements regarding the review period and revocation periods still apply to that severance today?
Well, that's a good question, Suzanne. So the under the Age Discrimination and Employment Act, for employees who are 40 or over, you generally have to give them 21 days to consider a release of claims and 7 days to revoke if they want to change their mind. If you're letting 2 or more people go for the same reason, COVID pandemic, then you need to give them 45 days to consider the agreement and then 7 days to revoke. And there's some additional legal requirements for those types of releases to be effective under the AGE Act. Now, with respect to unemployment benefits, they should be disqualified from getting benefits. If, for instance, you're giving them 2 weeks of severance, they shouldn't immediately get to double dip through unemployment for those first 2 weeks.
The employer still needs to make the application for unemployment,
right.
but to disclose that severance has been paid. The challenge is if the employee takes advantage of the waiting period, there'll be a period of time where you don't know if they're going to get the severance or not. Although as a practical matter, my experience is most employees will go ahead and sign quickly. They're not going to wait. They need the money.
For sure. Okay, one more question, and then I want to ask you about some resources that you would recommend for reference. Here's a scenario that's come up a few times. If you've got an employee, an exempt salaried professional employee that is working from home, and the employer is perhaps suspicious about the extent of the work that is actually being completed and demonstrated. How far do they push that right now, particularly if the employer just happens to know personal circumstance that that employee has children at home, but it is economically better for that employee to continue to receive their full paycheck by working from home? How do you suggest an employer handle that scenario?
Well, interestingly, the guidance under the FFCRA says that if the employer agrees, the employee can take that leave intermittently to take care of children. So it may be a discussion point where if the employee admits they need the leave, then the employer can say, oh, okay, then you're going to get your pay under the FFCRA instead of full salary. But that is a tricky scenario that may be better discussed via kind of a counseling and coaching approach than denial of pay.
Well, and we haven't talked about wage hour very much, but wage hour definitely comes to bear on these situations, because if you have exempt salaried employees, what the law says is you're supposed to pay them their salary regardless of the number of hours worked. But if you've got a cash flow problem, an income problem, one option would be to reduce the salary. And again, you'd have to be able to articulate the business reason why. Remember, in January, the minimum salary for exempt employees went up to $635 a week. So you couldn't do it below that. Another option, and we saw this a lot during the recession, is to convert salaried exempt employees to non-exempt employees and only pay them for the hours worked. They have to track their time, and then of course if they do work more than 40 hours in a work week, you have to pay them time and a half. Usually if you're talking about reducing someone's salary, you want to keep them, but you don't have enough work for them to do anyway. So usually the overtime isn't really an issue. But those are some other things to keep in mind are the wage hour rules. It's always okay to convert an exempt employee to non-exempt as long as you track hours and pay overtime. It is never okay to convert a non-exempt employee to exempt and just try to pay him a flat salary regardless of hours worked. Again, if they're for the non-exempt, if there's less than 40 hours and they're at least making minimum wage, which is $7.25, then perhaps practically speaking, it's not an issue. But when we do pick back up and people's hours expand, that'll be something to pay attention to.
Great, thank you. And so lastly, given where we are on time, I just want to ask if you both had any resources, websites that you would recommend for employers as your suggested go-to to help weed through some of this info or take a deeper dive into specific scenarios.
Well, if you're a complete glutton for punishment, the FFCRA regs just came out last night. They're 124 pages long, so get your adult beverage and dig in. But the easiest thing, very accessible, U.S. Department of Labor website, dol.gov, has excellent guidance on the FFCRA and other kind of COVID-19 related questions. So that's one. Wade had mentioned the EEOC's ADA pandemic website. Again, just plug in EEOC ADA pandemic and you'll find that I had previously mentioned the OSHA COVID-19 guidance, and the Georgia Department of Labor also has been really good about updating its website. It shows the guidance, the Q&A, the FAQs. I mean, it is really doing, I think, a very good job of trying to educate folks. What else, Wade?
I would echo everything that Sarah says, and again, as easy as it is to criticize government, the governmental response within the last week has been really fast, and there's some really tired staffers in Washington because they're putting together a lot of information fast. For a non-governmental website, SHRM, SHRM website is, I think, very good and offers a different perspective because it's, of course, a trade group, pro-employer trade group, but good information on that website as well.
That's great, thank you. And we will include those URLs to the class as a follow-up. I want to thank you, Wade and Sarah from Hunter McLean, our employment expert go-to resources, as well as Leadership Southeast Georgia alums. Thank you so much. And thank you. Looks like we've had 33 folks join us this morning. So as a reminder, we will be doing these sessions on about a weekly basis as we plan them out, and remaining optimistic and hopeful that we can see the class again live and in person in June and again in August. But of course, we will be communicating with you as we go forward if those plans do change. We are going to keep these sessions to an hour, and it looks like we're a couple minutes over. So you know me, I like to keep us on schedule. And thank you again, Wade and Sarah, but I'm going to go ahead and close us out today. Thanks all for joining. Take care. Bye, everyone.